Good evening. My name is Marie Dorigny. I'm the Paris director of the Columbia Institute for Ideas and Imagination. Thank you for joining us for Jesse James' talk in our SNF Rendez-Vous de l'Institut series, where you get to hear our fellows talk about their work. I've been lucky enough to have many conversations with Jesse over the past few months, and I can't think of a topic that doesn't interest him, make him pause and want to know more. So it'll come as no surprise to you that in addition to having a career as a litigation attorney in New York, Jesse is also a classicist, a classical and legal historian, an archaeologist with an interest in Greek epigraphy, an expert in Thucydides, was once a carpenter, speaks ancient Greek and Latin, some modern Greek, and has a knack for sophisticated French vocabulary questions that I cannot help him with. Thanks for the humiliation, Jesse. In a couple of months, he'll be able to deliver this lecture in French. Jesse was trained as a lawyer at Berkeley and holds a PhD in classics from Columbia University. Among the many awards and fellowships he's received is the Burger Howe Legal History Fellowship at Harvard Law School, the German Archaeological Institute Fellowship, the Pro Bono Publico Award from the Legal Aid Society, and he's also a member of the American School of Classical Studies in Athens. Courtroom Persuasion à la grecque examines the role of psychology in the courtroom and the continuing recourse to rhetoric in the age of scientific evidence. It also looks at how legal persuasion is in many ways similar to visual and performing arts, appealing to emotions, expectations, biases, the unconscious, a form of expression where the interaction with the audience affects its feelings and perception. So Jesse is very much at home at the Institute. Jesse will explore the Greek origins of these practices and how they influenced modern Anglo-American and European legal systems. Over to you. Thank you.
Thank you, Marie. I am very much at home in the Institute, and that's thanks to Marie, largely to Marie. And so I want to start by thanking Marie and Mark, this sort of mad geniuses of the Institute here, along with Meredith and Sari and James and the rest of the Reed Hall crew for all of your guidance and assistance and warmth and positive energy. Thank you to the Institute in general, the Institute for Ideas and Imagination for the fellowship this year, to Columbia University for founding and supporting the Institute. Special thanks to the Stavros Niarchos Foundation for supporting the Institute's work and for all the support that the Stavros Niarchos Foundation gives to creative and social efforts around the world. To my fellows who've created such a stimulating, supportive, and collaborative environment, thank you. I also want to thank I'll get through the thank yous eventually, but I also want to thank the library of the École Normale Supérieure, as well as the Jean Glotz Library of the École Pratique des Hautes Études, which have been wonderful places, very welcoming for me to do research while I've been here. And finally, thank you to the city of Paris for its glamorous charisma, which somehow makes all of us feel that the city loves each of us the most. So, and thank you all for being here this evening. Now, this is a work in progress. It's a chantier, as Thomas called his work a few weeks ago. I like that term for work in progress because it literally means construction site. And it's not only because I used to be a carpenter, but whereas Thomas's work was if you were here, you would have seen it, his work was a construction site of a largely complete building. He was able to walk us through an actual structure, although maybe the bathroom still needed to have the tile installed or the kitchen cabinets weren't in yet. But I'm presenting a chantier at a much earlier stage in the process. Basically, the building lot is cleared. There was a hole in the ground, giving a vague idea of the footprint of the final structure. So let's imagine it together. Part 1. Americans tend to think about their law in isolation from other legal systems. Yes, of course, there are English legal roots, but they're so old. And besides, the Declaration of Independence of 1776, even more, the Constitution of 1789, and finally, the major amendments to the Constitution after the Civil War were transformative legal measures rendering prior legal history irrelevant. The usually unspoken assumption, then, is that American legal history began in the late 18th century. Since then, the United States have been on a legal trajectory all their own. Just the opposite assumption dominates thinking about ancient Greek law. It is deemed a dead end of legal history, of no relevance after the hundreds of more or less independent Greek cities were absorbed into the Roman Empire, and especially after all those Greeks became Roman citizens in the year 212 CE. On these assumptions, almost 1,600 years separate the terminus ante quem of Greek legal history and the terminus post quem of American legal history. This evening, I hope to begin to show that these assumptions about Greek law and American law are wrong, and both for the same reason, because Greek law has had a definite influence on American law. To show you how, I'll begin by discussing a recent trial. In 2021, in the state of South Carolina, the wife and adult son of a prominent and wealthy lawyer, Alec Murdaugh, were shot from very close up with powerful guns on one of the family's large properties. After a long investigation in 2022, the police charged Alec Murdaugh himself with the murders. The trial took place early last year. The judge commenced the trial by speaking to the jurors. He explained to them that he and they had entirely distinct roles in the trial. His role, or one of them, as judge, was to determine what legal rules were applicable. It was up to him to say what the law is. Once he did that, the jury's role was to determine the facts of what had happened and apply those facts to the specific laws the judge gave them. The judge pointed to the witness stand next to him and said to the jurors, "You will determine the facts of this case from the testimony which will come from this witness stand, together with any exhibits made a part of the record or any stipulations entered into by counsel." By applying their facts to his law, the jurors would arrive at a verdict. As soon as the judge had finished describing the strict manner in which the jurors should determine their verdict, the narrow sources the jurors could use for that purpose, the prosecutor stood up to address them. Delivering his opening statements, he spoke for 30 minutes straight. Most of those 30 minutes were devoted to offering the prosecutor's version of the facts. His story of how, as he alleged, Alec Murdaugh had slaughtered his wife and son. He also described some of the legal rules the judge would tell them to abide by. The prosecutor was followed by the defense lawyer, who countered with his own half-hour-long opening statement in which he told an alternative story and emphasized different laws. Neither of those opening statements was delivered from the witness stand the judge had pointed to. Neither counted as testimony. Neither was admissible as evidence. Neither could be taken as an authoritative statement of the law. And officially, the jurors were forbidden from using either of those opening statements to determine their vote at the end of the case. The opening statements did offer the jurors attractively packaged, coherent versions of the facts and the law. Each offered a narrative, a story, and both were made in the hope that the days and weeks of testimony and evidence that followed, the actual presentation of the admissible facts of the case, would be, in effect, superfluous. The lawyers on both sides hoped the jurors would accept, at least provisionally, his version of the story as it came from his lips, and make up their mind in that first hour of the trial before presentation of the case had officially begun, something that studies show often happens. The trial lasted 5 weeks, 5 weeks of testimony and evidence submission, 5 weeks of presenting and cross-examining witnesses and exhibits. In the 5th week, when all the legally admissible evidence had been offered, the lawyers got the last word, another occasion to sway the jurors with their own inadmissible version of the facts and the law. These closing statements, addressing all the strengths and weaknesses of 5 weeks' worth of evidence, arguing for and against various possibilities and likelihoods, were much longer than the opening statements. The defense lawyers spoke for over 2 hours, and the prosecutor for 3. They took this time to offer their own spinning summaries of the admissible evidence and telling the jurors how they should apply it to the law. Practically every jury trial in the United States follows this pattern: a warning from the judge to the jurors about what they should listen to, followed by apparently complete disregard for that warning. It doesn't matter whether it's a criminal or civil trial, whether it's in federal or state court. This pattern points to a gap and a tension in the American legal system between an ideal and a reality, between a simplified, surface, unattainable, and perhaps misguided ideal, and a deeper, more complex, and maybe preferable reality. The ideal is that purely neutral jurors with no preconceptions will take a set of disembodied facts and apply them in an entirely unbiased way to the clear text of a written law. The reality is that the lawyers on both sides try their hardest to get certain evidence admitted and other evidence excluded, to get the law phrased in the manner most favorable to their client, to make witnesses look simple and trustworthy or devious and dishonest, to make themselves look and sound wise and reasonable, to make their story more plausible, to make the jurors like their client, and to make the jurors sympathize with their side and despise the other. The basic reason for this tension between an ideal and the reality is that the two components of the American legal system seen as most characteristic and essential are also the two components that are least trusted: the jury and the lawyers. The jury is in some ways seen as the heart and linchpin of the entire trial system, so reliable that its findings of fact can be overturned only under the rarest of circumstances, so trustworthy that jurors' deliberations are protected from any outside observation or intrusion. It's left to the jurors alone to determine the relative weight they'll give to the admissible evidence, any of which they can ignore or emphasize at a whim. And it's up to the jurors alone to determine how much credibility to grant any witness. In these respects, the jurors receive great deference and exercise immense authority. At the same time, jurors are infantilized and distrusted by the system. Though jurors have almost absolute discretion in weighing the mass of evidence put before them, an infamous set of restrictions is placed on what kind of information can be included in that mass of evidence. These restrictions are called the rules of evidence. Perhaps the most famous of these is the exclusionary rule, which prohibits use in a criminal case of evidence that has been unconstitutionally obtained from an unreasonable search or seizure. Much more ordinary is the rule against hearsay. This notoriously complicated rule is presented as a blanket prohibition, but in fact has dozens of exceptions. Courts do their best to conduct even the debates about what evidence is admissible outside the jury's presence. The common justification is that jurors can't unhear evidence. If they hear the debate over admissibility, they'll have a good idea what the contested piece of evidence is. If it's ultimately ruled inadmissible, they might still consider it in their deliberations, any prohibition by the judge notwithstanding. This practice is especially infantilizing of jurors because it doesn't apply in bench trials. These are the trials held without a jury, where a single judge rules on all the legal issues, including the admissibility of evidence, and on the facts drawn from that evidence. In a bench trial, therefore, the trier of facts is exposed even to the evidence whose admissibility she herself rejects, something avoided in jury trials. Then we have the lawyers. Lawyers play such a prominent role in legal process in the United States that it's described as an adversary system, as opposed to the inquisitorial procedure of European-style civil law systems. Calling the American legal system an adversary system also highlights the centrality of the two opposing parties, both usually represented by lawyers. In American litigation, the interested parties are entirely responsible for bringing charges, investigating the case before trial. During trial, they decide which exhibits to offer, which witnesses to call, what questions to ask those witnesses. They make and contest any appeals, and they pursue any judgments awarded by the court. The adversaries and their lawyers are the driving motor at every stage. They have enormous freedom in developing and presenting their cases, both factually and legally. And in the United States, lawyers' most emphasized ethical duty is to be zealous advocates for their clients. But partly as a result of this highly adversarial nature of American law and of lawyers' duties to be vigorous advocates, lawyers aren't much trusted in the United States. The legal system itself, of which they form the left and right hands, so to speak, doesn't trust them. Often they don't trust each other. This is another purported function of the American rules of evidence, to prevent scheming, tricky lawyers from introducing irrelevant, confusing, or prejudicial evidence, to hinder them from using their lawyer's rhetoric to pull the wool over everyone's eyes. Now, some will defend the American system, arguing that the tension it creates between zealous advocates on one hand and the restrictions of the abundant rules of evidence on the other, with jurors as democratic arbiters of fact and a neutral judge keeping a stern watch over the whole proceeding, is the greatest means ever devised for discovering the truth and adjudicating the law. Others find it to be a strange, irrational, inefficient, and frequently unjust system. But on either view, it's distinctively American. The unique form of American litigation, its special relationship between jury, adversarial lawyers, and rules of evidence, took its particular shape over the course of the 19th century. The causes of it taking the shape it did are complex, and so I'll focus on just a couple of them by making two main claims this evening. My first claim is that the American legal system is not as independent, distinctive, or isolated as it's sometimes assumed to be. This is because the adversarial roles of the lawyers and the arsenal of techniques they use to argue cases, some of the very features that make us distrust them, have been influenced by ancient Greek rhetorical methods of arguing legal cases. American lawyers have long taken Greek rhetoric as a model, whether consciously and directly, or without even realizing it. Now let me elaborate on this first claim. Here in Europe, it's widely acknowledged that one ancient legal system has been enormously influential on the development of European law, including French law. This is the Roman legal system. Roman law, as a coherent system of substantive legal rules bound by juridical reasoning, is still widely studied in European law schools and seen as having at least some slight relevance to the modern practice of law. But ancient Greek law, as I mentioned, is seen as an historical dead end, even by specialists of it. Yes, Greek philosophy, literature, drama, art, and architecture are well known to have been supremely influential on the Roman versions of those fields, as well as on later European developments. But to the extent people think about it at all, they say ancient Greek law was replaced by the quite different Roman legal system before the latter went on to have its long and illustrious afterlife. This attitude holds even in modern Greece, where people are especially cognizant of the enduring contributions of ancient Greeks. But it's premised on an unjustified severing of legal rhetoric from law, taken as in an overly narrow sense. Now, one main route by which Greek courtroom techniques reached American lawyers was through Roman rhetorical authors who had themselves been heavily influenced by Greek legal rhetoric. Cicero and Quintilian are the two Romans most famous for adopting and adapting Greek rhetorical theory. So the Greek influence is also via a Roman influence. Now, my second claim, which I'll discuss more briefly this evening, is that this Greek and Roman influence on the argumentative techniques of American lawyers also affected the development of American evidence law. The rules of evidence changed in ways that made even more useful the rhetorical techniques eagerly adopted by 19th century American lawyers. The system changed from one in which entire classes of witnesses were prohibited from testifying to one in which the confrontations of lawyers and witnesses before the audience of a jury became the heart of a trial. This system favored and was encouraged by lawyers with thorough training in classical courtroom rhetoric. Water time. Okay, part two. To go back to my first claim, that American lawyers still practice Greek legal rhetoric. Rhetoric itself is a Greek word, rhetoric, and for 2,500 years, people have often used the word rhetoric in a negative sense. Empty rhetoric, a specious, deceptive way to persuade people with bad arguments or false promises. But I use it in a neutral sense, following Aristotle and taking rhetoric, more specifically legal rhetoric, to be the use of all the tools available for proving a legal case. These rhetorical tools include the law itself, evidence, witnesses, cross-examination, logical argument, and everything lawyers can say or refer to. Legal rhetoric includes the language lawyers use, how they dress in court, how they speak and intonate, even how they move around the courtroom. All of these are aspects of presenting a case, and all count as rhetoric in the Greek sense. Under this broad definition, legal rhetoric is a kind of Gesamtkunst, a complete art of the litigator or barrister. Plato famously denied that rhetoric was an art, what the Greeks call a techne. At least Plato denied that rhetoric was an art as it was practiced in 4th century BC Athens. He thought it was a kind of knack or an unteachable skill. But Aristotle and most other ancient rhetorical theorists disagreed with him, as do I. And of course, like most arts, when done well, legal rhetoric doesn't make all its techniques obvious. So I'll introduce a few elements of Greek legal rhetoric and show that they're still used today by American lawyers with illustrations from the Alec Murdaugh trial. A central concept of legal rhetoric is proof. This is the usual English translation for the Greek word pistis. Aristotle divides proofs, or pistes, into two main kinds, what he calls the non-artistic, or the atechnic proofs, and the artistic, or entechnic. Non-artistic proofs are the things not invented by lawyers. They include what we call evidence, witness testimony, material evidence such as weapons, blood, fingerprints, DNA, relevant documents such as contracts, wills, receipts, financial records, phone records, emails. Non-artistic proofs also include any laws that are relevant to the dispute. Artistic proofs, on the other hand, are the arguments and other forms of persuasion supplied by the lawyers, created by them through their art and skill in lawyering. You might say the non-artistic proofs are the raw materials to which the lawyers apply their artistic proofs, their lawyering skills in crafting a case. Now let's compare Aristotle's scheme to what our judge in the Alec Murdaugh case said to the jurors. Remember, he said the case would be decided based on two sets of things: the law, which he would give them, and the witness testimony, exhibits, and any facts stipulated to by both lawyers. Everything the judge listed counts as a form of proof under Aristotle's theory. In this respect, the American legal system hasn't introduced anything new. And so the judge would have to admit that even in the idealized version he presents to the jurors, the whole trial would be based on rhetoric in an Aristotelian sense. And the judge distinguishes, as Aristotle does, between law and fact. But as I pointed out earlier, the judge omits much of the picture. He mentions only the non-artistic proofs. He seems to be simply pretending the other kind doesn't exist. Yet, as my metaphor suggested, without the artistic proofs, the non-artistic are simply inert matter. The jurors and the judge both need the lawyer's art, the art of legal rhetoric, because this consists of taking the facts and the law and combining them into a coherent presentation of a legal case. The judge's implied version of how the court operates, based solely on non-artistic proofs, on evidence and law alone, is not only idealized, it's entirely false and, frankly, impossible. We need things like reasoning and argument, narrative and probability, both to connect the facts of a case to each other and to interpret the law and apply it to the facts. In other words, the artistic forms of proof are absolutely essential to litigating and deciding a legal case. Now, I should clarify, I don't think the judge would disagree with me about the necessity of reasoning and narrative, but I think it's telling that he omitted to mention those as elements of the litigation and of the jury's process for arriving at a verdict. Artistic proof itself, the techne side of the coin, is not monolithic. Aristotle divides artistic proof into three categories, what he calls logos, ethos, and pathos. Logos is persuasion through logical argument, forms of induction or deduction usually. Ethos is persuasion through character, which happens in two ways, either through taking into account the character of the audience, crafting your arguments to the personalities, circumstances, and values of the jurors, or through the speaker's character, speakers making themselves appear to be trustworthy and to have good judgment. Aristotle calls this latter form of ethos practically the most authoritative form of persuasion. So if you're persuaded at the end of my talk, it's because of the ethos that I'm projecting. Pathos, the third kind of artistic proof, means emotion. Proof through pathos includes all the ways of making jurors feel emotions such as friendliness, kindness, and pity for your side, but anger, hostility, annoyance, and indignation against your opponent. Now, when the prosecutor in the Alec Murdaugh trial made his opening statements, he carefully wove together the three forms of artistic proof, while also giving a preview of his version of the facts and the law. Water. Okay, I'll quote the beginning of his address to the jurors. So he said, "On the evening of June 7th, 2021, at the kennels of Alec Murdaugh's property off Moselle Road in Colleton County, at about 8:50 p.m., next to the feed room, Alec Murdaugh took a 12-gauge shotgun and shot his son Paul in the chest and shoulder. The evidence will show that it was 1,000,000 to 1 chance Paul could have survived that shot. But after that, he shot him again, up from below the chin, and did catastrophic damage to his brain and his head. Paul collapsed right outside that feed room. And just moments later, Alec picked up a .300 blackout AR-style rifle and shot his wife Maggie just feet away. Pow! Pow! 2 shots, abdomen and leg, and took her down. And then more shots, including 2 shots to the head that did catastrophic damage and killed her instantly." So the prosecutor opens with pathos and ethos, emotion and character. He tries to immediately engage the jurors' horror, anger, and pity. He describes the wounds as catastrophic. He adds the pity-evoking details of Paul collapsing and of Maggie lying on the ground and getting shot in the head. And he makes the defendant look especially vicious with his claim that the first gunshot wound to Paul was already enough to kill him. The second shot then looks even more like cold-blooded evil. This is the prosecutor's opening characterization of Alec Murdaugh. The prosecutor does something else here that isn't, strictly speaking, a form of Aristotelian proof, but that Aristotle recommends. He gets right to the point in telling the jurors what the case is about. Aristotle says this is the most important thing to do at the beginning of a judicial speech. The prosecutor then added a bit of logos, some logical reasoning. I quote him again. "Neither Maggie nor Paul had any defensive wounds, suggesting they didn't see any threat from their attacker, and both were shot at extremely close range. They were shot at close range, and they did not have defensive wounds." Now, the prosecutor's obvious implication, the logical conclusion he wants the jurors to draw, is that the attacker was someone Maggie and Paul knew and trusted. Then, from logos, right back to the ethos and pathos. Maybe I should just hold the microphone. The prosecutor continued, "And the cell phone evidence will show that Alec, although he insisted to anyone who would listen that he was never at the kennels that evening, he actually was there just minutes before Maggie's and Paul's phones would go silent forever and ever. He was at the scene and told everybody he was never there. Credibility, ladies and gentlemen, credibility." Now, here the prosecutor is especially evoking the emotion, the pathos of pity, with his dramatic line about their phones going silent forever and ever. And he's characterizing the defendant's ethos as a liar, whom the jurors therefore should not believe. Prosecutor then shifted gears and switched focus by introducing himself and his team. He said, "Ladies and gentlemen, my name is Craig Waters. I'm with the Attorney General's office, and I'll be the lead prosecutor." Then he started pointing out some people in the audience. "With me is David Fernandez, Savannah Gao, John Matters, Don Zelenka, John Conrad, and Johnny James." Not my cousin. A lot of lawyers. This is a big case. It's a very complicated case, and that's why there's so many people working on it. Sitting in the back row, we have David Owen, who's the lead investigator, Lieutenant Charles Gent, Special Agent Ryan Kelly, Special Agent Peter Rodolfsky, some of the agents that are working on the case, as well as Investigator Isaac Toledo. There's some of the witnesses that you'll hear from as we go through this case. Now, with this shift of tone, the prosecutor abandons the pathos, but maintains a subtle ethos-based form of persuasion. He moves from painting the defendant as a vicious, lying murderer to humanizing himself, portraying himself as an officer of the law and part of a large team of other representatives of peace, law, and order. He does it quickly and subtly, but still effectively. He does something else here that Aristotle says you should do at the beginning of a court case. He makes it sound big and important. Aristotle says that jurors pay more attention to big, impressive things, so the courtroom speaker should make it look like he's talking about a big and impressive case. Now let me shift from prosecution to defense. We heard the first few sentences of the prosecutor's opening, where he describes the brutality of the crime, evoking ethos and pathos as though straight from the pages of Aristotle. Well, the defense attorney took a different page from Aristotle, the one about refutation. The defense attorney also emphasized, right at the outset, the brutality of the crimes. He was even more graphic, warning. I quote just part of what he said. "When I say they were slaughtered, ain't no question. When Paul was shot the second time with a shotgun, the gases from the shot literally exploded his head, like a watermelon hit with a sledgehammer. All that was left was the front of his face. Everything else was gone. His brain exploded out of his head, hit the ceiling in the shed, and dropped down to his feet. Horrible, horrendous, butchering. So, to find Alec Murdaugh guilty of murdering his son, you're going to have to find that he executes him in a brutal fashion. Not believable. Not believable." Now, Aristotle, I can put this back. Aristotle says that one way to make a refutation is to make an opposite argument from something your opponent says. Here, the defense attorney is taking something the prosecutor used for ethos and pathos and using it as logos, making an argument from probability. This crime was so brutal, there's no way a father would do that to his son. It's an illustration of a central point of Greek rhetorical theory, that many proofs can be turned on their heads by a skilled speaker. I could go on, pointing out all the ways that the strategies used by lawyers on both sides illustrate the techniques of judicial oratory theorized by Aristotle. I could discuss the prosecutor's repeated metaphor of Alec Murdaugh as a storm that overtook his family. I could talk about his physical theatricality before the audience, his voice modulation, his use of a regional accent and diction. And I could go beyond Aristotle and bring in other ancient rhetorical theorists, Cicero and Quintilian, and the unknown authors of the Rhetoric to Alexander and the Rhetorica ad Herennium. I could add examples from actual Greek and Roman court speeches that still survive. And I could bring in lawyer speeches from many other recent American trials. But I don't have time to do that. And even if I did, at the end, although Marie didn't actually give me a deadline, so... and even if I did, at the end, you'd probably still want to ask me a question you might already have in mind. You may be asking yourself, okay, Jesse, sure, you can use ancient Greek rhetorical theory to analyze these lawyers' speeches, but that doesn't mean the Greek theory actually played any role in shaping how American lawyers argue. How do we know the principles they used for arguing their cases weren't just rediscovered by American lawyers over the past couple of centuries? After all, Leibniz and Newton both independently invented calculus and right about the same time. And calculus is much less obvious than arguing a law case. Maybe American lawyers have simply invented their own form of rhetorical calculus. Now, it's true that many American lawyers don't realize how much their litigation techniques owe to Greek and Roman rhetoric. But this isn't because the debt is not real. Yes, many modern training manuals omit references to ancient sources. Some manuals simply portray their teachings as timeless truths about presenting your case that you're supposed to think the author himself came up with or herself. But other modern practice guides do still refer to ancient rhetorical advice, making the debt explicit. So, for example, in 2008, Antonin Scalia, who was then a justice on the U.S. Supreme Court, co-wrote a book with Brian Garner called Making Your Case, The Art of Persuading Judges. This book is marked by emphatic references to Aristotle, Cicero, and Quintilian, whom the authors often quote as providing the foundational authoritative statement of a principle. For example, in one section, Scalia and Garner advise the litigating attorney, "Your objective in every argument is to show yourself worthy of trust and affection." In support of this claim, they quote passages from Aristotle and Isocrates, emphasizing the importance of ethos. In his 2005 book, Introduction to Classical Legal Rhetoric, A Lost Heritage, real page-turner, Michael Frost claims that despite previous neglect, a growing number of modern lawyers, judges, and legal academics have begun employing classical rhetorical principles in their analyses of legal discourse. A few years before that, Stephen Jamar, in an article called Aristotle Teaches Persuasion, claimed that the value of knowing Aristotle's rhetoric is increasingly recognized by some advocates and by teachers of law school courses and legal writing, law and literature, evidence, and legal reasoning. Both authors cite a number of books and articles from the second half of the 20th century offering advice for litigating attorneys based on ancient rhetorical theory. In a 1986 article for practitioners called Brush Up Your Aristotle, Robert Hanley, a partner at a major law firm, perhaps exaggerated slightly when he claimed, "Aristotle created the art of rhetoric, and no work on the subject since is comparable. It stands apart and above. Aristotle's rhetoric is essential reading for anyone who would persuade others. Aristotle's rhetoric taught Cicero and Quintilian, and its basic precepts serve as anchors to every good book ever written on persuasion." In the 19th century, though, ancient rhetoric's influence on American legal practice was more direct and more pervasive. So let's jump back to 1836. This is when David Hoffman published the second edition of his 2-volume Course of Legal Study, which he presented as a complete syllabus for aspiring lawyers. And back in those days, most lawyers didn't actually go to law school. There was maybe one law school in the United States, so you did do a lot of self-study. You would study under an attorney. So in a section of this book titled Forensic Eloquence and Oratory, Hoffman notes, "The student scarce needs to be reminded by any remarks of ours of the importance of this branch of his legal accomplishments." And here, in addition to a number of modern works at the time, modern works on the subject, most of which were already heavily influenced by classical rhetoric, Hoffman recommends and describes the theoretical treatises on rhetoric by Aristotle, Cicero, Quintilian, and Tacitus, as well as collections of speeches by Lysias, Isocrates, Demosthenes, and Cicero. Decades later, in his 1880 manual, Rhetoric as an Art of Persuasion from the Standpoint of a Lawyer, Daniel Miller offered his considered opinion. "I studied many American and English authors on the subject of rhetoric, but found nothing in them to compare in usefulness and thoroughness of instruction to Quintilian's Institutes of Oratory. He, it appears to me, has left nothing unsaid on the subject of rhetoric which can be profitable to study or know." I will vouch for the thoroughness of Quintilian. Henry Hardwick's 1903 book, The Art of Winning Cases, is pointedly subtitled Modern Advocacy, but even his modern advocacy relies on the still useful ancient authorities. Hardwick stresses the importance of studying Cicero and even uses examples from Cicero's speeches to illustrate his advice. It's probably no coincidence that Rufus Choate, the Boston attorney who was celebrated on his death in 1859 as perhaps the most consummate lawyer the United States had yet produced, was famous also for his devotion to classical rhetoric. He had studied Greek and Roman rhetoric since his college days, reading Aristotle, Cicero, and Quintilian in the original languages. He had busts of Cicero and Demosthenes in his home office. Choate advised law students to soak your mind with Cicero, and he memorized the entire text of Demosthenes' famous speech on the crown, which takes up 100 pages in the original Greek. The legal historian Amalia Kessler has argued persuasively that 19th century American lawyers' obsession with classical oratory fueled the transformation of the American legal system into the highly adversarial system that took shape during that century and survives today in what many consider to be a swollen, hypertrophied state. Kessler focuses less on the specific forms of Greek legal rhetoric adopted by American lawyers than on the attitude of lawyers' initiative and courtroom adversarialism that it fostered. She speaks of lawyers aflame with the spirit of civic republicanism fanned by ancient rhetoric. The most prominent place for lawyers to demonstrate their civic virtue was in the courthouse, where they saw an ever larger role in the legal disputes they were involved in, valiantly and vocally advocating for their clients. To Kessler's analysis, I would add the observation that the Greek legal system in which ancient legal rhetoric was born was, if anything, even more adversarial than the American system has yet become. At least in Athenian law, which we know best, juries were larger, they could fill up a space like that, and more powerful than in the United States. There was practically no judge figure at all, and seeking justice relied even more on party initiative. So it's hard to think of a more apt influence than Greek rhetoric for pushing American lawyers into adversarial attitudes and behavior. Okay, part 3. It was precisely during this rhetoric-infused, increasingly adversarial 19th century that the American rules of evidence took their modern shape. My second main claim is that classically inspired rhetorical adversarialism stimulated that change. Now, arguably, the fundamental principle of evidence law has always been relevance. Is a piece of information relevant to proving or disproving the legal charges? But English and American law have never allowed all relevant evidence to be considered by courts. They have always had rules for excluding some portion of it. At the beginning of the 19th century, the most important way to do this was by simply forbidding large classes of witnesses from testifying. In the early 1800s, under most circumstances, courts would not hear testimony from children, people of color in many states, convicted felons, atheists, non-Christians, and members of certain sects of Christianity, people with a financial interest in the dispute, spouses of the parties, or even the plaintiffs and defendants themselves. By the end of the century, in all states, the sweeping witness competency restrictions had been removed from every one of those groups except young children. In 1900, practically anyone could offer witness testimony in any American courtroom. Why did these changes take place? Well, the legal historian Judd Campbell recently showed that the religious disqualification was eliminated first. The old rule was that only Christians who believed in an afterlife where they would be punished for perjury could be trusted to tell the truth as witnesses under oath. But the United States in the early 19th century was like the Asian fusion restaurant of Christianity. A seeker could find, it seemed, every conceivable variation, including some, like the Universalist Calvinists, never heard of them before, who denied the existence of hell. Because religious belief would not obviously prevent them from violating their oath on the witness stand, they could be disqualified as witnesses. But the American religious ferment that offered so much variety also frothed up into a movement that equated religious disqualification of this sort to a restriction on freedom of religion. One might be tempted to think that once the religious disqualification was found to be unfair, any basis for witness exclusion started to seem irrational. But it wasn't so simple. In fact, later debates over the further dismantling of witness disqualification rules don't even make much of the fact that religious disqualifications had already been eliminated. They emphasize instead the ability of juries to discern when witnesses are telling the truth or not. especially when jurors see witnesses exposed to careful cross-examination by adversarial lawyers. The virtues of cross-examination in this respect are praised, among many other places, in an anonymous article published in 1857 in support of allowing parties to be witnesses in their own cases. The anonymous author, wrote, "The parties would be subject to the same tests as ordinary witnesses. They would take the same oath, an awful and solemn promise before God and man. They would submit to the same cross-examination, at once the most perfect and effectual system for the unraveling of falsehood ever devised by the ingenuity of mortals. The minutest circumstance, the smallest fact would be forced upon the mind of such a witness. There could be no escape from the vigorous sifting of his testimony. If he is refractory, he will be met by a determination equal to his own. If he is equivocal, he will be pushed to the wall and made to declare himself explicitly. Conscious that everything depends upon his own story and appearance, he will be scrupulous in his statements, not deviating from the exact truth. His voice, his eyes, his manner will be remarked and commented on by the jury. If, in spite of all these guards, he lies successfully, he must be a shrewder man than most of his fellows, for he must not only deceive the opposing counsel, but the judge on his bench and the jury in their box." Now, lawyers themselves probably welcomed the possibility of having more witnesses testifying in court. Amalia Kessler has argued that American lawyers' willingness, even eagerness, to cross-examine witnesses arose from their belief that it offered a lawyer a broader canvas for public display of his eloquence and intelligence, a chance to show himself as a crusader for virtue, devoted to promoting the public good, pursuing virtue and trampling vice. Her argument is persuasive that lawyers used cross-examination to make themselves look like virtuous citizens. But cross-examination also offered a more immediate and concrete strategic legal advantage. It gave rhetorically trained lawyers a broader field for practicing their techne. To put it in Aristotelian terms, more witnesses testifying meant not only that the jury could consider a larger amount of artless proof, namely testimony, it also meant that lawyers had more opportunity to exercise their artful proofs. 19th century lawyers understood that examining witnesses, and especially cross-examining them, required the most careful practice of the lawyer's art. In his 1836 work, which I mentioned above, David Hoffman declares, "Great knowledge of the human character, the art of adapting his manner to its varieties, penetration, equanimity, amiableness, clearness of expression, etc., are requisite in extracting the precise truth from witnesses." Cross-examination could backfire upon the unskilled lawyer, especially with respect to ethos and pathos. In his 1876 lectures on the study and practice of the law, Emery Washburn warned that aggressive cross-examination could make the lawyer look bad. He writes, "There is one rule which one ought to observe in cross-examining witnesses, both as a lawyer and a gentleman, and that is, never badger and browbeat a witness, as some lawyers do, as if he had been guilty of a positive crime in testifying. Such a course can hardly fail to react upon the party who indulges in it, as it awakens a sympathy at once in the minds of the jury in favor of the, to them, innocent object of it." Edward Parker, a longtime colleague of Rufus Choate, the famous lawyer I mentioned earlier, published a long volume of his recollections of Choate shortly after Choate's death in 1859. This guy Choate was so famous that someone wrote a 600-page memoir about him right after he died. In one passage, Parker shares Choate's advice about cross-examination. He writes, "Choate has told me never cross-examine any more than is absolutely necessary. If you don't break your witness, he breaks you. For he only repeats over in stronger language to the jury his story." Parker continues, "Except in occasional cases, Choate's cross-examinations were as short as his arguments were long. He treated every man who appeared like a fair and honest person on the stand, as if upon the presumption that he was a gentleman. And if a man appeared badly, he demolished him, but with the air of a surgeon performing a disagreeable amputation, as if he was profoundly sorry for the necessity." Compare this practice and advice to the ancient advice of Quintilian, whose writings Rufus Choate knew intimately. Quintilian advises the cross-examining attorney that the cross-examining attorney should question a hostile witness only the minimum time needed to get what he needs. He cautions especially against what he calls the sensible and steady witness. This person must be either 1, sent away at once as hostile and obstinate, 2, refuted by a brief intervention rather than a long interrogation, 3, thrown off balance by some witty observation, or 4, destroyed by the scandal of his offenses, if anything can be brought against his way of life. It has proved useful to show restraint in attacking honest and modest witnesses, because people who would have fought back against an attorney's onslaught are often mollified by his courtesy. These passages highlight one of the systematic advantages of cross-examination. It reveals not only which witnesses are not credible, by the same process, it helps clarify to jurors which witnesses they should believe. Vigilant and rhetorically trained lawyers assist the jurors in their central task of determining witness credibility, a task that became much more important as more and more people were permitted to testify under oath. And lawyers were probably more supportive of eliminating the rules, excluding large classes of witnesses, when the lawyers' careful study of Greek legal rhetoric made them more adroit at dealing with witnesses. More generally, by helping to teach lawyers in the young nation to be eloquent, energetic, and effective advocates, Greek legal rhetoric nourished an adversarial American legal culture, a culture in which the lawyers on both sides were relied on to uncover all the weaknesses in the other side's case, to reveal which witnesses were credible and which were not, and to furnish the jurors with the proofs they needed to be able to reach a verdict in any case. Greek legal rhetoric fit the American legal system so well because it was born from legal institutions even more adversarial. And although 2 millennia ago, Greek cities abandoned their native law for the edicts and jurisprudence of the Romans, Greek law still survives in a certain form in the adversarial backgrounds that are the courtrooms of America. Thank you.
Thank you, Jesse. As far as chantier go, this is pretty good. It looks as if there are buildings coming up nicely. I have a question about the design, perhaps.
Okay.
Why was there this urge to not be influenced by the Greeks? Why sort of position in the 19th century, in the sort of founding moment of a new nation, why not want to anchor what we're doing to the classical tradition, to the Greek tradition, in the way, for example, education is, like the core that you and I teach at Columbia is sort of a perfect example of, like, we in 20th century America, it's the sort of the last stage of a development that started way back in ancient Athens, right?
Yeah.
Why this need to sort of distance and say, no, we're doing something new, something different?
Well, I think in the 19th century, they were drawing the connection explicitly, and that it's really, it's more in the end of the 19th century and in the 20th century where the connection is forgotten, largely forgotten. I think that there's, and I would say that Columbia is a strange place and the core is weird. Like, that's very atypical of American education, right? So I would say, in fact, you're giving the exception that proves the rule that in America, for a long time, we've not been obsessed with drawing these connections. And to me, that's become really much more clear since I've spent more time in Europe, Greece and France and Germany, where there's so much more awareness and interest in connections to classical antiquity. And I think in the United States, it was something that a conscious debt and a conscious connection and a conscious use of classical literature and rhetoric was really pronounced from the end of the colonial era until around the time of the Civil War. And that, I think not coincidentally, is also when a lot of American legal change happened, foundational legal change and formation happened. And that by the end of the century, in laws, among lawyers and in law schools, and this is part of where I still have a lot of research to do. But what I've seen so far is indicating, and I cited a couple of late 19th century sources, that mention classical rhetoric, but I think that it was still being cited by lawyers and in law schools, but less. But I think that there's a natural tendency to just forget about old sources. I mean, this happens with scholars, right? You want to cite people from the last 50 years or something, not something from the middle of the 19th century, unless you're really showing off, you really want to show off how much research you've done and how learned you are, because you've gone all the way back to the 19th century. Or in the case of like Scalia and Garner's book, I think they're probably two conservatives who are trying to sort of kind of make a point about the advice we're giving has this pedigree, and so there's this American democratic anti-antiquity, anti-elitism that tends to forget and drop out the references and the influences to antiquity. But lawyers are still kind of exceptional, I think, in wanting to create that connection. I don't know, that was a long rambling answer. I don't.
Thank you so
Dorothy.
much. I find it totally fascinating and convincing. And then I was thinking, as somebody who came over to the States to study and remained there, but being partly European educated, what stunned me so much in the States was the attention paid to rhetoric. I mean, it is also part of an American school system and ambitious kids that they have these debating societies and hone their rhetorical skills, which totally stunned me.
Yeah.
Smart kids go to debating societies and you'll see it in their writings, and then where does it go? I guess it goes to politics, yeah?
Mm-hmm.
And then you have this, in America, a denigration of politics as rhetoric. But nevertheless, if you want to become a politician, you have to be a good rhetorician.
Yeah.
And so my question is, in that kind of trajectory of the way the American legal system evolved and drew very fundamentally, as you showed,
Yeah.
on Greek rhetoric, without in the 20th century or later 19th century acknowledging it much. I was very convinced up to the rules of evidence. Have you at all looked at, say, in a way, the political education and the denigration of rhetoric in the same kind of time span? I mean, I'm not sure how that fits together or whether it fits together, but it seems sort of a stunning contrast.
Yeah, thank you. I haven't really thought about that. One thing that I have seen that people have talked about is just how we think nowadays that there's a lot of lawyers in politics, but in the early United States, it was even much more so. Like 13 of the first 16 presidents were lawyers, and 50% of Congress was lawyers, and et cetera, et cetera. And so it could be that part of the reason that there's been that, maybe there's sort of there's a natural connection between being interested in the law, wanting to practice law, and also being interested in politics and wanting to practice politics. But how does that connect to the fact that both groups use rhetoric a lot? And maybe...
on the one side, it's kind of veiled, at least.
Yeah.
And in politics, if it's called attention to, it's denigrated. But it's sort of with growing politicians, it's cultivated.
Yeah. Except I would say people like to talk about Obama being able to give a very good speech, for example, or people like to talk about, of course, Lincoln's rhetorical ability. So there are times when it's praised, but most of the time it's the negative view of rhetoric, which is very, very old. Like I mentioned, it goes back. It's before Plato, probably. It's this distrust of people sort of making the weaker argument the stronger. This fear that you're being tricked somehow by a skillful speaker, it's a risk.
Thank you very much, Jesse. That was marvelous. I'm thinking about the story of juries in the account that you've given.
Uh-huh.
It sounds from what you're saying as though the principal address for rhetoric in the courtroom is toward the jury. But presumably, I don't know what the history of juries in the U.S. Trial practices are, and I would like to hear a little bit about presumably there are legal traditions in which juries play little or no role in the practice of trials, in which there are panels of judges. And in fact, you did mention the bench trials in the US, in which there are no juries. So I'm wondering whether the question of rhetoric is principally about the jury.
I would say no.
You'd say no.
I would say that is a very important aspect of it. But the Scalia and Garner book is about, it's subtitled, it's How to Persuade Judges. It's actually specifically about people who are lawyers who are going to be presenting their briefs and giving oral arguments to judges. And of course, Scalia was on the Supreme Court, and so so much of his experience was about people making arguments to the Supreme Court. Legal rhetoric is really, it's in every, I would say, and I think most lawyers would agree with this, it's in every litigation document, every litigation communication that a lawyer has. Any letter to the other side, the briefs that you file with the court, the oral arguments to the judge. But the rules of evidence, so that specific element that I'm talking about, that I'm focused on in part 3, that's all about trial. And it's about what gets to the jury. And so that's why I was focusing on that aspect. And the other thing is, nowadays, 1% of cases go to trial. So you could be a lawyer for years, a litigator for years, like I was, and never go to trial. I never went to a trial. I never worked on a trial. I went to court a few times, but most of the litigation. You
never had the opportunity to make use of your rhetorical skills.
Yeah, so the really refined performance you saw this evening was not honed in the courtrooms.
Thanks a lot for your presentation, as well as for allowing us to imagine the scene of an actual courtroom where you made the mise en scène of the dialogue present in the text used in an actual court. And on that note, I was wondering about the picture that you chose to show us, because actually we've never seen the stage, the tiles of an ancient Greek amphitheater. So I'm wondering, because I see in the middle you have this square, but then also you have around it. How did it look like in that time? Is it made on purpose? So is there a certain mise en scène for? And by the way, is it am I wrong by saying that it's an amphitheater? Because I believe you mentioned it's an Odeon.
Yeah.
What would be the difference between an amphitheater and Odeon? Then I guess I have two questions, but also about the tiles of a stage of the. Thanks.
Well, maybe I should call up my architectural expert. So basically, thank you for your question, and thanks for asking about the photo. So this is an odeon. This is the term used for it, which is sort of like a small theater that was originally in a covered building. So there would have been a roof on this, and it's smaller than an ordinary Greek theater. So it's not a theater, it's an odeon, because a theater is larger, usually significantly larger, and open air. And then an amphitheater is a Roman creation, which is two theaters sort of face to face, so that it creates an arena, an enclosed arena. And I put up a picture of an odeon because odeons were multi-purpose civic public buildings for various kinds of performances. And an odeon could have held in certain cities, certain kinds of trials at least would have been held in a building, in an odeon or a building like an odeon. They also would have been held in other kinds of buildings, also in the open air. There were a variety of venues that different kinds of trials would have been held within, and you could have juries of just a few people, or you could have juries of up to 1,000 people, and it would depend on the city and the case and the era. And so even within Athens, you had juries of widely varying size. But this is not Athens. This is from Mycenae in the Peloponnese. And I'm not actually sure when this odeon was built. I forgot to check that before this. So it's possible that it was Roman era, but I believe it was when Mycenae was still an independent Greek city. So.
Jesse, thank you very much. This is captivating. I'm one of these people who, since I've been a kid, would go and drop in at the cour d'assises at the courthouse.
Oh yeah, we still need to go together.
We do need to go together. I will be happy to take you there. And I go as a spectator. I have no legal background at all. I go to listen to the rhetorical skills and to the mysteries of what happens in the courtroom. But I sort of want to follow up on David's question about, because there is something that puzzles me about what you're presenting or how this unfolds, because my understanding is that when the lawyers are developing this rhetorical sort of art form, it seems to me that if you're speaking to the Supreme Court, you're speaking to a public of extremely sophisticated analysts of rhetorical skills, which is very different than speaking to a large crowd of a jury in the Odeon, which is very different than, say, in France at the Assises, where it's a mixed bench and jury system, where you have, I believe, 12 jurors and 3 magistrates sitting together and deliberating together, which is very different than, say, the trial experience that I had in New York, where I was in a jury sequestered, and we had to deliberate by ourselves without anybody in the room, without a grown-up in the room to explain what was going on, and we were completely lost. Yeah. Having listened to 3 weeks of bad rhetoric, because it was, public defenders and sort of third-rate prosecutors, but trying to figure out what to make of all this, and it was a very chaotic and sort of nonsensical deliberation in many senses. So I guess my question is, in the way you're looking at all of this, you're looking at sort of the genealogy of the use of rhetorical skills, but the structures within which these skills are used vary from sort of country to country based on how the court system functions. And so what do you make of these distinctions, because the addressee is different and the rules are different.
Yeah, thank you. Well, I would say, let me just talk briefly about the French system, because like I mentioned, it's sort of, it's a different genealogy, because so the American system American common law system with a sort of English style jury grew out of English common law, and was pretty different from the origins of the continental European systems, this sort of what I call the inquisitorial system, where the judge or judges are much more involved in the development of the case. And there's, even though, like I said, there's still rhetoric at every level. It's not as rhetorical. It's more maybe what a Greek would say dialectical. The two different kinds of argument and persuasion being rhetoric and dialectic. Dialectic being sort of more strictly philosophical. but they really bleed into each other. Yeah, I mean, there's a huge variety of venues, and there's going to be a huge variety of skill levels, and it will depend on, even in the United States, there's plenty of venues, like family court, for example, is a huge example where there's no jury. You go to family court, and the individuals are there, hopefully with lawyers, and they're just talking. They're sitting in a small room talking to the judge about what's going on. It's a much less rhetorical situation, and so you're going to be using rhetoric less in that kind of case, and you'll have a lot of unskillful rhetoric, as you always had in ancient Greece as well. And we have these speeches that survive from Demosthenes and Cicero in Roman times and Isocrates, etc. Those are considered the best of the best, the finest examples. So you could also read versions of 19th century legal speeches from the United States that would be these, well, I mean, even just the manuals from the 19th century are very flowery and rhetorical. And if you compare to modern courtroom, there's less taste for that kind of in-your-face rhetorical performance. But I think it still is happening. You still have these litigation manuals that really emphasize basically all the same points for lawyers who are going to go to court as the ancient Greek manuals did. So you have a lot of variety, I think, but the fundamental advice mostly remains the same, I think. Is that responsive? Okay, thank you.
Thank you, Jesse. This is really just out of curiosity. I had no idea that such a small percentage of cases went to court, went to trial. And is that, you can only speak from your personal experience, but is that quite disappointing? I mean, could that push a lawyer to go into academia, for example?
Trial is terrifying. The lawyers who go on trial, they sort of sequester. You think the jury gets sequestered, the lawyers sequester themselves, and they rent hotel rooms and work 16-hour days for weeks at a time. It's a debate about that. First, I think we should distinguish between criminal and civil, because maybe there's a different evaluation of what's going on. Criminal law, it's really this huge push toward plea bargaining. And one criticism of that system is that prosecutors end up charging defendants with worse crimes than they think they can actually prove in order to try to coerce the defendants into copying a plea for a lesser crime, one they actually think that maybe they can prove, rather than having them go to trial and getting it tested by a jury. I recently saw a defense of the equivalent in civil litigation, where most cases settle before trial, and the basic justification was that the reason that happens is because American discovery is so elaborate now and so thorough that by the time the two parties have shared all the information that the court forces them to share with each other, all the emails and, well, it's largely emails nowadays, all the emails and other documents, it's pretty clear which side is right and which side is wrong, and they can settle the case without having to go to a jury to determine the answer. So it could be that it's actually a pretty good result in civil litigation, and people would say in criminal law it's just a necessity. There's no way that all those cases could get tried. The system would be backed up for a decade or something like that. So it's tough. One more question, all right.
Thank you so much. I found it completely fascinating. I'm just wondering about the leap between ancient Greece and Rome. What about the period of Alexander the Great and India with Ashoka and his edicts? And of course, it was Sakamuni who created the concept of common law. And that filtered through into Greece, didn't it?
This is beyond my pay grade. But I would say just Alexander the Great period, it was, Greek cities were still had their own legal systems and they were following their own Greek law at that time.
Yeah, with the Gandhara, and then you're in India with Ashoka.
Yeah, I don't know.
And he was writing edicts in Greek and Sanskrit. I mean, it was all bilingual because
Okay.
he was managing the borders of these two civilizations. But that kind of law, which was a common law, and it was
Yeah, and then there were
completely-
the laws
and
of
then
Manu.
just one comment. I loved what the woman said about going into politics, and I could only think of a wonderful, terrible example, Boris Johnson, who studied the classics and was the top of his debate team at the Union in Oxford. I mean, he uses rhetoric and nothing else. Is it because of his classics studies in Oxford?
Absolutely.
I think so. Thank you so much.
Thank you.